Okay. So I did start the recording and I'll start the meeting. Welcome. This is the Criminal Justice Moral Fitness Workgroup, December 17th, 2024 at 1:03 p.m. We're here at DPSST in the boardroom and then also on Teams. This is the administrative statement. This is a public meeting subject to public meeting law. This meeting will be digitally recorded and posted on the DPSST YouTube page after the meeting. The meeting will also be recorded in the form of written minutes. Discussion of issues will only be conducted by workgroup members, and please be mindful of comments and side conversations. That said, we'll start with introductions, and I'll begin. Jennifer Howell, DPSST Administrative Rules Coordinator.
Carol LaShawn, Oregon Department of Corrections.
Mark Daniel, Manager of Police, representing Oregon Association Chiefs of Police and the Police Policy Committee.
West Park Public.
Kathy Fink, DPSST. Cindy Park, DPSST.
Jennifer Lavario, DPSST.
Melissa Langbacho, DPSST.
All right. Online, we have Erica Stolhan.
Yes, Erica Stolhand, Hood River Sheriff's Office.
Thank you. And Chief Hanlon.
Hi, Ty Hanlon, Sherwood PD.
Thank you. And Kathy McAlpine.
DPSST.
Thank you. Is the audio okay for you all online?
Mm-hmm.
Okay. A little wonky in here, so. All right. Kicking off, the next agenda item is a quick review of draft rule changes for the applicant review committee membership. When the work group met in October, we asked you to review membership requirements for the applicant review committee. The work group recommended 3 changes. We put those recommended changes into draft rule changes. We'd like for you to review and approve those rule changes if you find that they accurately reflect your recommendations. Taking a look at the draft rules in your memo, it is the actual strike-through changes happen on page 2. There you'll see the recommended change, changing the board member position from public member to any member of the board. Just a note, this doesn't eliminate public member representation opportunities. Any public member from the board or a policy committee is eligible to be nominated and appointed to the applicant review committee. And historically, we have often had at least one public member from one of the committees nominated and appointed to serve on the applicant review committee. Section 3 shows the recommended deletion of the experience prerequisite and deletion of the option to vacate a policy committee member position if appointed to the applicant review committee. Section 3 also includes some amendments to help clarify the nomination and appointment process to support implementation of your recommended changes. I'd be happy to answer any questions. It's not a super official process. If you all have consensus, then we'll continue to move forward with this process. Any questions from online? Okay. In the room?
Mark Daniel, for the record, do you just need consensus or do you need a vote?
Yes, it's just consensus. So by our discussion here, we'll move forward. So just to help you understand what the next steps are, we did take advantage of the current applicant review committee meeting schedule. They met in November. We were able to share this draft with that applicant review committee group, and they were also supportive of the changes. And again, there was consensus as well because all of them sit on policy committees. And now the proposed rule change will go to the policy committees for review and approval. Then we'll have the public comment period. So let's see, that's February policy committees, March public comments, and then forward to the April board for a final approval. So we could look at implementation of these membership changes effective around May 1st. So that's kind of what the process looks like.
Thank you.
Yep. All right, thank you all so much. So that takes care of agenda item 2. And 3 is the meat of our conversation today. That's going back to our memo from October 16th, reviewing the receipt and administration of complaints that DPSST receives. During the October meeting, the work group covered discussion items 1 through 4, and I was just going to provide a brief recap of that to help kick off the next pieces of our conversation. So when DPSST receives a complaint against the public safety officer, staff review the complaint to determine if it's jurisdictional. And in other words, does that conduct, if proven true, fall under a board or DPSST scope of authority? We consider it jurisdictional if it involves a minimum standard for employment training or certification that's found in statute or rule. In either case, whether it's jurisdictional or non-jurisdictional, the complaint is forwarded to the employing agency. If the complaint is outside of board jurisdiction, DPSST notifies the complainant that the allegations are non-jurisdictional, forwards a copy of the complaint to the employing agency. DPSST takes no more action on the complaint. If there's a possibility that the complaint may fall within board jurisdiction, if proven true, DPSST forwards the complaint to the employing agency. The complainant is notified that that complaint goes to the employing agency and that any further investigation of the complaint is deferred to the employing agency. Then by rule, DPSST requires that agency to respond, acknowledging that the complaint has been received and reviewed and they took whatever steps that they wanted to take with it. And then if we receive response from the employing agency, again, DPSST takes no more action on the complaint. There was a Secretary of State audit that was conducted in 2021 that recommended that DPSST require more information on complaints that are jurisdictional. The audit recommendation stated that for complaints containing allegations that would violate the statutory and administrative rule requirements for certification, that DPSST should be requiring the law enforcement agencies to include a brief synopsis of what they did with the complaints forwarded to DPSST, including whether there was an investigation of the complaints, whether the underlying allegations were substantiated, and whether any discipline was imposed. So during the meeting in October, the work group considered that audit recommendation, and the discussion then supported moving forward with steps that would meet that audit recommendation. So having DPSST pursue the changes that we would need with administrative rule to make that a requirement. As I mentioned, that would result in rule changes and process changes. Some of the work group members during that meeting had identified that there are already similar processes in place internally within agencies where they're already responding in that manner to the complainant. So they would just then also be administering that process with DPSST. The discussions that we had also had awareness that the DPSST complaint record is a public record. And that we would need to also be mindful of the employing agency's due process, the due processes that have to that the agencies go through when they're doing an internal an investigation into a complaint, and then if there's any imposition of discipline. So to confirm, DPSST would have a record of the complaint and then have a record of the response from the agency. Both the complaints and the response from the agency would be part of the public record. And it could be obtained by someone through a public records request. So I had a pause here to find out if there are any questions on the initial handling of complaints before we move on to what to do with complaints that are scheduled to go to a policy committee. Kathy.
Well, if I could add another wrinkle in this, but I think it comes kind of before we take a complaint to one of the committees that we're just dealing with now, and that is we have outstanding complaints and they're with the agency, in this case, in particular, sheriff's office, when you have an election and maybe the current sheriff is not up for reelection or didn't win, and you're handing off. When maybe those complaints have to deal with the incumbent that's coming in, and how do we ensure we get that information back? So I don't know, Jennifer, or to this group, if it needs to be specifically put in rule, but what we're faced with right now is we know that we have some complaints that are outstanding that if it could be, the discipline is likely, and it's definitely within our jurisdiction on a moral fitness. And so how do we get that information back? And whether that's adding on what the SOS recommended, but right now, part of our process is to have Cindy at this point, because she handles our complaints, to reach out to any outstanding, because you could have chiefs that are retiring too, and check on the status of the complaints. And so we can kind of keep track and not lose those. But we have others who are basically by their county commission to stand down, don't make any personnel decisions in their final 30 days or whatever. And so we know that there is some complaints that could fall through the cracks that DPSST should be reviewing. So just kind of want to put that dynamic, since we're just faced with that right now. If that makes sense.
Les Youngbar for the record. I'd like to know how Kathy, or what kind of language would, and where would Kathy put something in this to cover that, or how you would do that?
Yeah, I think that, you know, and I apologize for kind of going off the cuff, because it was just discussed today, so I hadn't even had a chance to vet it out with Jennifer, but it's worthy of this group, at least, even if we have to table it to understand we have a couple other dynamics. And so whether, it could be with the work group's recommendation, what the SOS said, that basically we want to get all available material and make that determination. Or if we specifically talk about end of terms, whether it's a chief or sheriff, and we put in a process where we're reaching out to them to see what the status is, and they can then respond as to if they have an investigation, but they're been told not to make any final decisions. But then we could ask for it. So do we have the authority to ask for an investigation when at that point we don't know if there's going to be a separation? And so there's a few nuances to what we're facing right now.
So what I'm interpreting is the underlying question is what to do when we submit a complaint and it's basically been put on hold while the person who's received it is either directed not to do something about it or on their way out. So they're kind of deferring any action. They don't want to take any action.
Yes, in these particular cases, and it was my first year doing it in an election year, but I think we doubled our complaints. A lot of it had to do with the election stuff, which we can navigate and understand. So we had these complaints in plenty of time, gave it to the agency. Agencies were definitely looking into it and opened an investigation. So we know an investigation occurred, but now we're coming towards the end, and now the current seated agency head is being asked not to make any decisions. And so in our current process, it's a little vague as to could we ask for the investigation as it is and then present it to the committee for further discussion. I think there's it's not quite clear in our current rules right now, Jennifer.
Okay.
Mark Daniel for the record. So Kathy, are you saying that, are you suggesting that we just get DPSST obtains whatever investigation has been done? Or, you know, waiting until the investigation is assured that it's been completely done? Because obviously we've had that challenge with, you know, on the policy committee, looking at investigations that weren't very well done. So I just wonder, until that CEO, until that sheriff or that chief has a chance to review it fully and then put their whatever signature, or maybe county commissioner is gonna put some type of signature on it, that it's gonna be held up at the agency until it's completely been blessed by county council or city attorney's office. I'm not sure.
Yeah, there could be that. It could get buried. It could, there are a lot of different things. And so staying in our lane, when, you know, when can we ask for them? So I think in broader terms, it's asking for status updates basically at the changing of an election year and or a chief retiring. Now, a lot of times somebody else is coming in, but what if that second in command was a person under investigation or taking over? You know, is there, and the complaint started with DPSST. So we basically, somebody has reached out to us to keep an eye on this. And so how do we get that information or shore up that process? And again, you know, Jennifer, I'm dropping this on you. And so if it's better to come prepared next time, but I wanted this group to know that it's real, it's happening right now. And even if the work group says, yes, we definitely hear where you're coming from and we'd like to close up those loopholes or holes in them, that could be helpful.
Okay. Well, let's spend some time talking about what we do with these steps, and then the steps leading up to a policy committee review. And then I also wanted to talk about what are those desired outcomes of by taking these steps and taking a complaint to the policy committee. So we may be able to tie your question and conversation in to all of that as well. So the next part of the complaint process is a complaint that may need to be taken to the policy committee for review. And what are the intended outcomes of such actions? So under our current rules and processes, DPSST does not conduct an independent investigation into a complaint. DPSST's rule with moral fitness standards and review of complaints filed against employed public safety professionals remains secondary to the employer, regardless of the severity or the frequency of the complaints of the alleged misconduct. However, our current rules do identify 3 scenarios in which DPSST can present a complaint to the policy committee. The 3 scenarios were identified as situations where there's no one to forward the complaint to. Is kind of my takeaway from whenever we drafted it in the first go around. So the first one is an administrative rule is 3C, and there is a copy of the administrative rule in your memo. So jurisdictional complaints when the employing agency is non-responsive to DPSST for request for response. So in part, that's a scenario that may come up with Kathy's question. We've submitted a complaint to the employing agency and we're not getting a response from the employing agency. So if we're not getting responses from the employing agency right now by rule, we could take that complaint to the next steps in the process. There's also 4, if the jurisdictional complaint is against an officer who's no longer employed. So we've received a complaint, but that individual is no longer employed with an agency. We don't have an employing agency to forward it to. What do we do in those situations? And the third scenario are the jurisdictional complaints against an elected official. And for purposes, this would be the office of sheriff that we're talking about. So with the office of sheriff, there's no employing agency or no authority over that individual in order to forward the complaint to. They are in an elected position. That was too difficult to say. And so there's no body that can remove them from that other than the public. So there is a step that was written into administrative rule after we first put our complaint rules in process between taking the complaint and sending it to the policy committee. A previous work group had suggested that DPSST collect some information and review some mitigation prior to sending it to the policy committee to determine if it could be resolved before going to the policy committee. So that process is also written into the administrative rule. DPSST notifies the subject of the complaint that we've received the complaint and that it's a scenario that would be forwarded to the policy committee. And then that person gets to submit their own written mitigation or rebuttal statement to the complaint. DPSST then can review that information and either determine that it isn't jurisdictional after all, or that there isn't a moral witness violation, even if the conduct were proven true, and then we can close it. If that mitigation or rebuttal isn't sufficient to show that there's no violation or it's non-jurisdictional, then we would still continue forward in that process of submitting the complaint to the policy committee. So then the next step is to take the complaint and the response and send it to the policy committee. And when we're doing that, we're asking the policy committee to tell us what to do. Do we close it as it is? Is there a basis for an investigation? And that's what's written into the administrative rule right now. Is there a basis for investigation? And I do want to talk about that language as well, helping us understand what is a basis for investigation. But let me take a look at notes here real quick before I get ahead of myself. So it's also important to note that if the policy committee does recommend that DPSST take the complaint and open a professional standards case, that our ability to conduct an independent investigation is limited. We would normally be limited to what records have already been produced. Was there a DA investigation? Was there some other source that had already reviewed the complaint information? We would be looking to collect what already exists. And of course, DPSST does not have the authority to conduct a criminal investigation. So I mean, we could request it, but we wouldn't be able to conduct it. It would be the person, whatever agency receives it, they would be making the determination on whether they would investigate it or not. Okay. So part of what I wanted to talk about was, well, first, are there any questions with those steps of the process? That kind of overview part. Looking online and not seeing anything jump up. Everyone in the room's tracking. So should there continue to be additional DPSST and policy committee review of complaints under these circumstances? The person who's employed, but the agency isn't responding, the person who is not employed, and then elected officials. That's part of what we want to nibble away at today. I did identify some challenges with the process. Challenges with those who are not currently employed. We may not be able to reach that person to notify them of the complaints and the opportunity for them to respond to the complaints. Response to a complaint is optional, just like submitting mitigation to a policy committee in a professional standards case. It's optional for that person to respond to the complaint and provide any mitigation or rebuttal. DPSST has to take the complaint and the response at their face value. We have no verification or follow-up to those two sides of the information. Moving forward on a complaint when an agency is non-responsive, but there's been a separation from employment or criminal disposition may be contradictory to some of our other processes where we wait for a criminal disposition or we wait for a separation of employment. And then, as Kathy had mentioned earlier, sometimes the complaints against sheriffs are driven by political agendas during election cycles. So that has come up as a complication in the past. I feel like I'm doing a lot of talking. I don't want anybody to jump in at any time. Let's see. I may just have to get through this part of it in order to really launch the discussion. I already reviewed that part, the PSST discretion. Yeah, I think let's talk about those scenarios and pick apart what it means to take a look at each of those complaints and what outcomes we want from continuing to look at those complaints, continuing the process of monitoring that complaint. So when an agency is non-responsive, and that goes back to Kathy's question, how do we get the information back and follow up?
Well, two choices, right? We're taking for the record two choices, right? Put it in OIR creating a specific law or rule that the agency has to abide by. Or ask nice, and if they don't, then what we currently find ourselves in, which is sometimes nothing, sometimes something, sometimes everything.
Cindy Park, for the record, we do currently have ask nice.
Yeah.
We have second, third requests and more than that, nice phone calls, that kind of thing. So we are trying to do that because we know, complaints do tend to get lost on desks that are full of paper. And so it is a factor that has to be considered. They sometimes just get lost in the shuffle of the daily work of the agencies.
And I'll just add for context, there is at least a fair amount of community members that think that we're a safe place to file the complaints. They do get disappointed when we notify them and say that we send it to the agency, because oftentimes they either don't trust the agency or they felt they haven't been heard. And so there has been opportunities for people to at least go to a third party group like DPSST to file their complaints. But because our investigative authority is zero, it doesn't accomplish what I think the community thinks we can do.
LaShawn Barr for the record, is there any current precedents for cases where you have a great deal of, say, evidence or confidence that criminal conduct was conducted and is not being responded to, or you could then refer that to like the AG's office or something like that. Or do you want to stay out of that fray?
I know that I don't have an answer to that because I don't review the complaints, but historically, I haven't heard of cases where DPSST was referring a complaint to an investigative authority to that level.
In my time doing and reviewing complaints, I haven't had that experience. I have had people that want to file charges for different things, and we can direct them to the proper agency for that task. But I haven't had the experience of actual, potential criminal evidence and things being presented to us.
Early on, when I would talk to them and explain what we can and cannot do, I've recommended that they contact DOJ only to learn that their DOJ refers them to us, we refer them to DOJ, and really neither one is meeting the needs of the community member.
So let's jump over again. So it sounds like what Chief Daniel said is we'd almost have to have some kind of statutory language to make it definite or clear, because nobody wants to jump in without, I guess, some kind of direction. It's complicated.
So if we have a non-responsive agency and we have the authority then to take the complaint to the policy committee, and the policy committee says, yes, this complaint and the mitigation, we would like to see a professional standards case. If DPSST opens a professional standards case and there's not a criminal disposition and there's not a separation of employment, now we've kind of taken ourselves into another lane that we haven't been in before. And is that an issue, or is that something that we need to, do we need to keep that lane available for use?
Okay, let's flesh out more again. Hate to be a pain, but so are you suggesting that, so the policy committee says, hey, we find cause here for an investigation. And then what happens at that? Who
investigates?
Is that where we are at the dead end here? Or?
That is another part of it. Yes, I skipped that part. I skipped what does DPSST investigate? How does DPSST investigate it? And I had skipped all the way to we investigated it. and is it appropriate to take action when when we don't have the usual causes for action that we follow for our other discretionary?
Hey, Ty Hammond for the record, just seeking some clarification. So when we say no response, what does that mean? I guess from my perspective, if a letter sent to my agency regarding a complaint, if I respond or we respond saying, hey, we've received it and we'll look into it, is that good enough? Or are you expecting then follow-up reports, or where is that cutoff of non-compliance, so to speak?
Thank you for the question. Right now, the administrative rule requires the response, and then it says, let me find the right package. The response that's being sent back to DPSST is in the letter that we send to the agency with the complaints, and it says, of the public safety professional named in a complaint filed with DPSST alleging behavior that may violate the statutes and administrative rules that govern. It says, I acknowledge that the information contained in the complaint has been reviewed and handled in a manner deemed appropriate by my agency. So that's all that DPSST requires as a response at this time. And then in October, the work group had supported taking that one step further to the Secretary of State's audit and expanding that to be a response that says whether an investigation was opened and whether there were findings of violation of what the findings were. I guess whether there was a finding of misconduct or not, and then whether it required discipline. It doesn't, not what the discipline was, but whether or not it required any discipline.
Yeah, and that's, I guess that was my clarification is, okay, so you get half of a response. This is what we're talking about. We need 100% response. Otherwise, we're trying to figure out what's next. So if somebody checks the box and says, yeah, I received it, we've looked into it, we've conducted our investigation. Now with the new language of the audit, that needs to be a part of the 100% completion, if I'm hearing you correctly. And that's what we're trying to make a decision on.
Well, even before factoring the new requirements of what must be reported back, even just dealing with what's currently required in just that, this basic response of it's been received and handled in the manner appropriate by the agency, that the agency determines is the appropriate manner. So if we don't, right now, if we don't receive any response to that, after multiple attempts, because we do make multiple efforts to engage and even engage with other individuals within the agency. So if not receiving a response from the person that it's originally sent to, who else within the agency or the city or county structure can be contacted?
And Jennifer, correct me if I'm wrong, because I've inquired. In our rules, there is the ability to assess a civil penalty on an agency. Historically, that has not been done for a non-compliance, correct? But would that fall under that if there were to a point where they were non-responsive and we do have something on the books? Was that what was intended with that civil penalty for the agency?
Thanks for the question. It is not. The civil penalty is written in statute to be specific to the training and certification timelines. So when an agency is hiring someone and then not getting them trained or certified within those statutory guidelines of the 12 months and the 18 months, depending upon what your certification is, that's when we're able to issue civil penalty, but that's the extent of that authority. So in essence, the elephant in the room is that DPSST doesn't have teeth to enforce even the requirements to send the basic response. All we could do is find some way to show that someone is being non-compliant with the request. But by having an avenue to take it forward to policy committee, because that provides some sort of leverage. Like if you don't respond to us, we're going to take this complaint to the policy committee for direction.
Mark Daniel for the record, but if it goes to the policy committee, what is the policy committee doing? Because there's already no teeth, and I've watched this happen, where we haven't had enough information to do much of anything and asked DPSST to do more inquiries and to try and investigate more, gather more information. And I think that's just going to be a vicious circle at that point. I don't know that there's anything, unless we are in the business right now of creating those teeth. Unless that's what we want to do, as I mentioned before, by creating some type of legislative action, some type of organ administrative rule, which compels the department to do it. I don't know that it has even justification of moving forward to the policy committee.
I just wanted to ask
Uh-huh.
a clarifying question. I was under the impression that if policy committee directed us to open a professional standards case, that it would give us the teeth to collect records that an agency has, and that our statutes say that we can ask for those records even if someone's still employed and it didn't result in their in discipline. That we could take them to court if necessary for what was the
Access.
yeah, for access to
Okay.
those records.
No, and that's probably a fair interpretation of what authority could come from taking a complaint that's had no response to a policy committee. Because then, yes, the policy committee is saying, yes, open a professional standards case. And that for us is DPSST an investigation. And because there's an open case, we can request the records. But if there are still no records, I guess that's our finding, is that the employers didn't do an investigation or.
However, the officer involved will then there'll be some record of some type of information about that officer, which will result in administrative closure, becomes a part of the officer's file and can be utilized at a later date as information going forward with another case potentially. So it may not have teeth in the moment, but it does provide a record of something for future action.
Has DPSST gone to court through DOJ to compel an agency to submit records?
I think one time.
It's possible, yeah.
Or not in
But that was
complaints,
Not
with
stemming
complaints,
from a
but-
complaint from other professional standards cases.
Well, flesh on the bone. Once again, it seems to me that up front, the easiest thing to do is to actually just get some kind of language, some kind of OIR that requires, and just have that in the statement, you are required to respond to this. And then spell out exactly what there's, which you already have in language, but this essentially would say you must respond. It seems to me that would just expedite the process. They still might not respond, but at least
Right.
you've got that behind you. I know that's a complex process, but.
But am I hearing that there's still value in continuing through that process? The agency is non-responsive, therefore we collect the mitigation and rebuttal and determine whether or not it needs to go to the policy committee for the policy committee to tell DPSST whether to open a case or not.
Sure.
I think so.
Okay. Okay. So the next, and so then the theory then being that we'll work on a stronger requirement language to go with that. The second scenario was the individual who's no longer employed, and there's no employing agency to send the complaint to be investigated. Is that something that DPSST should still continue to look at through this current process, whereby we try to notify the complainant, if the subject of the complaint, if we can, and collect any mitigation and rebuttal, and if we can't, or we can't resolve it, then take it to the policy committee for more direction.
Let's see.
I do have one thought that since the time that we identified that scenario, we have now added to the background investigation process, the process that anyone who's hiring a public safety officer has to contact DPSST for professional standards records. And that includes records of complaints. So now we've enhanced the hiring process so that if someone's being hired, they have to contact DPSST, and DPSST would say, here are the complaints that we've received on this individual. So it doesn't mean that they would be investigated by that agency because they're looking to hire that person, but it's knowledge and information that then goes forward that would be considered as part of their hiring process. Not necessarily that the complaints would ever get investigated to determine if it was.
So to clarify, Cindy, for the record, it would go through committee. It would just be like more of a complaint was deferred, for lack of a better term.
Well, that's part of the question.
Okay.
Is what can we do with a complaint against someone who's not currently employed?
So Martina, for the record, is that what we're doing currently? I mean, are those complaints are being registered, if the person's not being, not currently employed as a public safety officer or whatever? And so we're telling background investigators, yes, Joe Citizen called in a complaint here to DPSST, the person's no longer employed. So here's the complaint that the person lodged for your information as you're conducting the background investigation.
Yes, for every individual. For every individual, even somebody who's hired and maybe is transferring to another agency or, but yes, but under our current process, we would look at that complaint and we would say, there's no one to forward this complaint to.
Right.
We have the ability to take it to the policy committee to find out if we need to be directed to open a professional standards case or not. So do we need to continue to maintain that process and those steps? Or is it appropriate to recognize that this person is not currently employed? And basically just say that the complaint is received, and then anytime they apply and they're under a background investigation, the new people would be advised of it.
So Mark Daniel again, if the policy committee reviews that information and then directs DPSST to open a case, then under at least our current process is the only action that it marks the person's certification under review, because there's nobody to do an investigation.
Okay.
And the information received post-employment as opposed to current employment.
Right. So there are almost two tracks.
Okay.
It depends on if the person had certification or not.
Right.
So if we assume that most of the individuals are certified at the time that they separate employment, and that we receive a complaint and the person is no longer employed, the policy committee says, yes, you should open a case and investigate this. DPSST opens the case. Because that person holds certification, we're able then to conduct whatever investigation we're able to do. Whether that, we just don't know what that investigatory process looks like or what tools we have.
Which right
To
now
collect.
is requesting documents and
Right.
those types of things.
Right. If the person was not yet certified, so if it was a newer person and they left before they were certified, we would not currently have any authority to investigate the case. So we would have to hold it until they became employed right now.
Again, so if they were certified and you did
Mhm.
your due diligence and you came out with a adequate amount of information, then potentially that person could be decertified, right?
Yes.
Yeah, well, I think that's important. If you do that, then you can eliminate somebody even going through the process of starting to hire. Or starting, but I mean, they don't have to go through the whole process.
right? And so, again, matching it up with the other side of our practices where we wouldn't have opened a case except for this complaint because there was no criminal disposition and the separation of employment wasn't a result of the complaint conduct. So we're taking this other path. Do we still continue to do that same thing for someone regardless of they're employed or not employed? Does it change it because they are employed versus not being employed?
Not in my mind.
I don't think so either.
So it's that receipt of information that a reasonable person would say, this is a violation of the standards. So even though you're employed, there should potentially be action taken against your certification.
Yeah, I think, Mark, taking it for the record, I think we should go down the same path.
Folks online having any thoughts?
Kathy McAlpine for the record. As you guys are kind of thinking about this and commenting, I have just a couple of concerns depending on, kind of the creep or the volume. Right now, Cindy, correct me if I'm wrong, we get a complaint, we look at what the complaint is, we identify the agency, whether it's jurisdictional or not. All that matters is the type of letter we send to the agency. But we don't check for their employment status first. We send it to the agency. So the agency can sign off and say, yep, we'll take a look at this. And we may never know if the person is employed there still or not. Is that fair to say, Cindy?
I usually look up the officers on Skills Manager, and as
You
long
do
as that's
first.
updated, I would know that they were employed or not.
Okay, good. Okay. Because that was my only concern is if we didn't do that step, then the agency, because they as of right now, without the SOS recommendations, it's just signing the form saying, yes, we will look into it. And then you don't hear anything unless there's two actions. One leads to a separation or it goes on the economic sanctions reported database. And that's the only way we know that there was an outcome that resulted in some form of discipline. Everything else is handled at the agency at the lower level as it should be, right? And with all the afforded union representation and guarantee rights and whatnot. And I'll just add one more thing, Kathy McAlpine for the record, as Chief Daniels indicated, already sometimes we bring cases forward to the different committees when the employee has elected to resign prior to giving a statement, and we'll still bring the investigation forward if we can. And I know that the committee sometimes is challenged without having their statements, or sometimes the statements don't come until they offer mitigation. And so if we open it broader to complaints without their statements or their cooperation, I think the committees would be hard pressed to make a determination as to whether or not a moral fitness violation has occurred without that additional information. Did I capture that correctly, Mark? Kind of what you were saying already, what you've experienced?
Agreed, 100%. Thank you, Kathy.
Jennifer Lavario for the record. I would just add to that, Kathy, that that's why we also have the administrative closure process, which allows DPSST to make the decision beforehand or recommend to the committee that we've already done this work and determined there isn't a moral fitness violation or we don't have enough information. So the committee doesn't have to necessarily do that when we don't have enough information.
Right, so if a non-responsive agency on a complaint and we either took it to the committee for direction, but again, do we have anything? Long and short of it is the question I'm putting out there for you guys to consider is all we're doing is creating more administrative paperwork and logjam on our end with very little outcomes. These are on non-responsive complaints.
What if we just said that the DPSST has the discretion to take non-responsive complaints to the policy committee to make it less of a requirement? And if we feel like there is an investigation that was done, that we could move it forward. Like
Yeah,
if
put it
there's
up
new-
put it up to all of you guys. What, I mean, in your respective disciplines.
Mark Daniel for the record. I have confidence that DPSST exercises good discretion. So I think that giving that discretion to DPSST is a good thing.
Yeah, Ty Hanlon for the record. I would concur with Chief Daniel in that, and the fact that it doesn't sound like we have a lot of teeth necessarily, but having that discretion to say that we have the opportunity or the ability to push some of these forward, I think might help light the fire, just knowing that these could move forward. Obviously no guarantees, but it's just, I think it's some good language on both ends for DPSST and then agencies to be on notice.
And that was for DPSST to have the discretion to forward a case to the policy committee, a complaint to the policy committee for direction.
For a
Okay,
non-responsive, yeah, oh, sorry.
Like if we saw through the news that there was reporting of an investigation that was done and we had reason to believe that there were records for us to obtain, that we could move those forward to the committee to ask if we should open a case. Or other methods. Perhaps it's not the news, but.
Okay.
Yeah, and Ty Hanlon again for the record. I know it does get a little slippery because we probably don't have a standard that we have to meet for each of these, but as it was already conveyed, I think that everybody there has been in the business long enough to know what needs to move forward and what doesn't in these kind of scenarios. And hopefully they don't occur very often. I mean, I think we're talking about, I don't know how many non-responsive we get, so it's probably pretty minimal unless I'm wrong there.
I'm Cindy Hart for the record. I agree. It's a fairly infrequent event, thankfully.
Isn't that kind of what the language currently says? Because it just says may present.
Yep. It does, it just kind of leads into as it's currently written, I think that the rule says it may be sent to a policy committee, but there's that process that's built into, we're gonna first notify the subject and collect the mitigation before we determine whether we will or won't. And that's, so it's the discretion with that piece. So, but it can be crafted to this discussion. Yeah, it can be. All right. So we deeply analyzed 2 of the 3. The third one is the even harder one. Those are the complaints against elected officials. And what types of things do we need to be thinking about whenever we're going through those steps and processes? We have a complaint against an elected official. There's no one to forward that complaint to, so we would pretty much automatically roll into the, here, Sheriff, here's the complaint. We're requesting your response for mitigation and rebuttal. And then DPSST receives that. And if it's super clear that it's a non-jurisdictional or non-moral fitness violation based on the mitigation and rebuttal, then the rule already gives DPSST staff the discretion to close it right then and there. But if it's not super clear, then staff are going to want the policy committee to look at the complaints and the mitigation rebuttal statement to determine whether, as the rule currently says, there's a basis for an investigation. So what kind of thoughts or questions do you all have on?
Mark Daniel for the record. So when you talked about this before, you kind of, at least in my mind, kind of inferred needing the definition of baseless for an investigation. So would that not be linked to the 2 previous discussions that we had? The fact that there's a complaint.
Right.
What would be the basis at that point?
Yes, and I guess that's one of the questions I have right there is, so the current rule says, where the policy committee finds no basis for investigating the complaint further, the department will close the complaint. Where the policy committee finds a basis for an investigation, the committee may direct the department to conduct an investigation and present the complaint as a professional standards case. So finding a basis for investigation, because exactly as you said, is the complaint itself basis enough for investigation, or are we asking the policy committee to identify more of the reason beyond the complaint?
Well, in the first sentence, it says a complaint is the basis for. So it stands to reason for me, it just follows all the way through. And if you've got a complaint, you've got a basis. It doesn't necessarily have to be substantiated.
So what's within a complaint and the mitigation rebuttal statement would the policy committees be looking at to say, yes, there's a complaint and there's a response, but what about this warrants opening an investigation? When DPSST would not normally be involved in conducting an investigation. So what are some of the factors that policy committees should be considering at that stage? Or do we need to change it from terminology of basis for investigation and align it more with the moral fitness standards, where the policy committee finds that?
I think it needs to be, Mark Daniel for the record, I think it needs to be more aligned with the moral fitness standards and not just hanging out there on the basis of a complaint, especially for the police policy committee. I would feel a lot more comfortable with that. Because once again, all you're going to be able to do is ask for records and documents, and whether or not they respond to DPSST's request or not. It's going to be up to them, and then whether or not DPSST chooses to go through the DOJ and get some type of court action to seek documents that DPSST might believe are
in existence, that would be available, but beyond that, I think that's where it needs to go.
Yep, Kathy?
Yeah, Kathy McAlpine for the record. We have a current scenario, and I think again, it's is it the cart before the horse when you can ask for those documents, and it's an interpretation right now of only when we have jurisdiction. So basically, we did open a professional standards. For example, we have some allegations, and on an elected official that will go in front of the policy committee. Now there's some statements in there that leads to believe other entities have already looked at that, whether that's DOJ, ethics committee, et cetera. And so when we talk about, if we're satisfied, we could request those or at least confirm that they were looked at and unfounded before we go to the committee. But is that asking for records and we don't really have standing because we haven't been assigned the investigation because the committee hasn't asked us to? Or do we go to the committee and say, this is the allegations, this is a mitigation by the sheriff, it's alleged by both parties that this was looked at, some of this stuff was looked at, yes, you guys want us to go and get those documents, and then we wait 4 more months till we meet again. So part of it is also clarifying to get other information to bring to the committee. In some ways, my instinct tells me to value your time and everybody's effort. If we know that we could at least come to the committee and say, half of these allegations, we were able to confirm that it was looked at by the appropriate agency, DOJ, ethics, et cetera, and these are the only standing ones. Or do we wait till the committee gives us the authority to look into them and request documents? And I know that that's been an internal discussion we've had, is the chicken before the egg.
Question for the record. So does it seems to me it would be more valuable for any of the policy committees to have all the relevant information they could possibly have. So, to do that, you need some kind of language, I guess, that says that the staff will gather all relevant or all, however you want to say it, information that they are aware of and present that to the policy committee. I mean, can you do that? Can you put that in somewhere?
We can absolutely explore it, yes.
I know it's
Yeah.
changing
Yeah.
how you do things, but
And I think that's just a matter of how things have been done in the past. And all we can do is take the recommendation through the steps and the processes. And so it may be that we can gather and request, we can make the request, but we may not have the ability to enforce the request. So we would just say that we made the request, we weren't able to receive this information. This is what you have to make your basis on whether or not to open a case. And then once the case is officially opened, then perhaps we have the more authority to compel compliance.
but there is a possibility that you could make a request, get the information,
Right.
and save a lot of time.
Right. And I think that's part of the question that Kathy is asking. Should we change our processes to gather as much as we can before going to a
Right.
policy committee?
Right.
Mark Daniel, I would support that.
we've talked about several of the discussion points that were in the memo. For you all, for staff, did you have any other questions that still felt unresolved?
No, Cindy Park, for the record, I think one of the good things for especially the complaints that go to the committee is just knowing where the line is. Because what we do when we send a complaint to an agency, it's very different. We look at it, kind of do a quick assessment, send it to the agency for completion. If I'm, we're taking especially the sheriff complaints as an example, where is the line? Where does it become an investigation and we've gone beyond what the scope is of this particular lane? So I think it's really helpful to have the discussion to come up with what is the process and how can we look at it differently than we have been to make it more effective and efficient for the committees to look at them.
So are you then speaking to the process of we've got the complaints, and
Yeah.
so instead of just saying because we have this complaint and we have this rebuttal, we send it to the policy committee, but gather what we can when we can, but going through that identification process of what the moral fitness violations would be that we're looking at, or
we do kind of that, but is how far can I go in trying to get records to bring to the committee? So is it, if it's publicly available and they can find them online, that's fine. Do I have to
Okay.
request records? Is that too far? What is the line for that? Is as far as much as I can get? Is that, that's cool. So that's just redefining the process for
Right.
this one, which I think is going to be the more effective way to handle it.
Mark Daniel with the record. Just sitting in the policy committee meetings that I've sat through, when looking at these cases, and I would advise or advocate to get as much as possible, because it's been very difficult making some decisions on some of these based on the limited amount of information that has been provided to DPSST.
So Kathy McAlpin for the record. So Jennifer is, I think what we're asking and needing, and I feel like we have the support of the work group today, is whether it's language clarification or stronger language, but at least in the scenario of elected officials where there's allegations of misconduct, there's allegations that other entities that looked at it, that just simply be knowing that we're going to bring it before the committee is our authority to get that information from these other entities. And then they're generally other state agencies, whether it's DOJ, ethics committee, things of that nature. And so is that considered information we would want to present that says that, yes, those things were looked into. And so we can eliminate that, and we're down to, like, the current one is 15 allegations. Maybe we can eliminate 10 of them and we're down to 5. And so it is, as Cindy said, if I know other independent agencies have looked at this, can I go ask for the documents before we even go to the committee as part of the consideration for them to determine whether or not to open a case? Like, there's independent information that would suggest we could, or there's independent information that says most of this has been handled and the complainant is just not satisfied with that other entity's investigation. And so giving us the clear language to obtain that information before we present it to the committees would be extremely helpful, and I think very valuable to the committee's time.
Yeah, Ty Hanlon, for the record, I think you're spot on, Kathy. I mean, we should be presenting everything that's available. And to your point, to weed out things that have already been vetted or investigated so that we're not reinventing the wheel or duplicating a lot of effort here. Now, whether or not they agree, you know, that's down the road. But yeah, I like that.
Mark Dana, for the record, in theory, you very well could come to the committee and request an administrative closure because you've already obtained enough information that it's a done deal.
Ty Hanlon, for the record, for clarification, Kathy, can you close out specific allegations? I know just the hypothetical or whatever you have 15 allegations and you can close out 10 and you don't have to take them all. You can just take whatever's left and present it. Is that correct? You don't have to have this whole package, so to speak, if not necessary.
I think we would present it as we received it, the complaint, which, you know, they didn't number them, but it for example, is about 15. Again, the sheriff has responded, but not bullet by bullet. So it's not clean to parse out. I think that in a staff report, we can be able to delineate that we were able to get records, again, because both sides are alleging that other entities looked at this, but nobody offered up any documents to prove their point. So we're left to a he said. And if we can obtain those ahead of time, which we're trying, we want to be able to tell the committee that of these, this is what that entity ruled on. And the only thing that's outstanding under a moral fitness would be X, Y, and Z, and then narrowly scope it. So, but right now where we're at is we're trying to get the records through like a public records request, as opposed to saying we absolutely have the authority to ask, let's say DOJ under an ORS, and that's what we're trying to get at is do we have to say we have an investigation as opposed to an active complaint? We need the information. So complaint versus the authority under an investigation. And I think that's probably a Jennifer rules and DOJ on our rules. But I guess what I'm hoping to hear from the committee is, yes, you would like us to seek out and have that authority so that it's very clear when we bring something to the committee ahead of time that you do want us to look at language.
Okay.
Yeah, Ty Hanlon, for the record, I would 100% agree with that.
Okay. So in summary, we've looked at all three scenarios that were currently identified by rule in which DPSST would continue review of a complaint process, and all three have still been found to be appropriate to keep carrying out current processes. And that we're looking for enhancements on the requirements to respond. And we're looking for enhancements on DPSST's ability to collect information before taking the complaint to the policy committee for further decision on what actions should be taken, whether it be further investigated or whether it be closed as not to be investigated by DPSST. All right. Any other questions or concerns on the complaints and how DPSST receives complaints and what DPSST does with complaints. Kathy, do you think that any of this helps address your first question about when we're not receiving information from an agency and they're deferring it to a later time?
It's a mixture of, I wouldn't say that they're not responsive. Because in this scenario we're living with right now, they were responsive. They're just, a higher entity is asking them not to take action. And therefore we're left with this open investigation down at the agency that I know what the allegations are. They would have a moral fitness arena to them, a jurisdiction. And so what does that look like when and unfortunately it has to do with the incoming elected official. And so those dynamics of ingoing, outgoing, and yet DPSST has an independent need to review this for a moral fitness violation. But I think that I think I've gotten some good input. It's just how do we make it work under our current rules as we are right now? But I think getting clarity in some of the enhancements as we're going to vet out, I think will also help down the road as well.
Anything else from online? Okay. Right. I don't have anything else. So I don't be so surprised. But yes, so if there isn't any other discussion, we don't have to keep drawing it out. That's fine. Okay, so we'll work on addressing the recommendations from today and getting all of that packaged up and prepared with all of the other recommendations that the committee has been putting together over the past several months. So right now, there's no reporting on agenda item 4, follow up on pending action items or discussions. I've just been continuously including that so that we have the space if we need to use it. For as far as the next work group meeting goes, I don't have a timeline for you right now, other than probably I would have a timeline identified sometime in January, and then be able to reach out to you in January for a future scheduling. But right now, it would just still be that same poll process. So nothing tentative or going at this time. We have some work to do internally before we come back through. But at this point, we've kind of gotten through all of the moral fitness standards rules and discussed them to some level, and now they just have to be assimilated and then brought back to you to make sure that we've captured everything and that you're still good with it going forward to committees. Anything else for good of the order or anything else? Thank you. Well, all right. So as always, I really appreciate the time that you take to come to our meetings and to review the materials and to have the discussions. So thank you so much. And to you all, happy holidays and safe winter. Yeah, happy holidays. Thank you.
Thank you.
Thank you.
I'm like, where is it? It should be those complaints. Man. Well, eventually it will be. It's just, so she
I
can
know,
tell
I was
through the
having a hard time
process.
finding.